Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain corporate director and officer conflicts of interest in Illinois. Let's first talk about corporate structure a little bit. So the owners of a corporation are shareholders, and the shareholders elect a board of directors to manage the big picture affairs of the corporation. The directors then elect officers such as president, vice president, secretary, treasurer, CEO, CFO, COO, to manage the day-to-day running of the actual corporation. So the directors make big decisions and meet once a month, once every 6 months. The officers are usually working on the corporation on a daily basis and managing the corporation, its regular course of business. In small corporations or closely held corporations, shareholders, directors, and officers can all be the same people. So let's talk a little bit about conflicts of interest. If officers or directors of a corporation engage in transactions between the corporation and themselves, or between the corporation and an entity in which they have a financial interest, and by engage I mean vote on those transactions, authorize them, or do whatever is necessary to execute those transactions, they can be held liable for a breach of fiduciary duty, personally liable, based on a conflict of interest, and the transaction can be invalidated. So the transaction can be undone, and the director or officer that had a conflict of interest might be held personally liable for any damage to the corporation based on the transaction. However, the director or officer will not be held personally liable, and the transaction won't be invalidated if the transaction was fair to the corporation at the time that it was authorized. So if it's a fair transaction, it's okay if the director has a conflict of interest when authorizing the transaction. However, the burden is on the director or officer to prove that the transaction was fair. So the assumption is that it was unfair. The burden is on the director or officer that had a conflict to prove it was fair, unless one of the following two things is true. And these two things basically come down to disclosing the conflict of interest prior to the transaction. So if the director disclosed the conflict of interest and the nature of the transaction to the board, and the non-interested board members after the disclosure voted in favor of the transaction or voted to ratify it, or if a committee that was authorized to do so voted in favor of the transaction or voted to ratify it after the fact, then the burden is not on the director to prove that the transaction was fair after the fact. The transaction still has to be fair, but it's presumed to be fair if it was disclosed ahead of time and the board voted on it, whether to ratify it after the fact or approve it to go forward. The second situation in which the burden is not on the director to prove fairness is very similar. It's if the director disclosed the transaction, all the material facts, and his or her conflict of interest to the shareholders, and the shareholders voted, the non-interested shareholders voted by majority to approve the transaction or ratify it. So essentially what we have is if a director has a potential conflict of interest or if an officer has a potential conflict of interest, it's their responsibility to disclose that conflict of interest and make sure that a vote happens that they're not involved in, and that the vote by a majority of either the directors or majority of shareholders approves or ratifies the transaction basically prior to there being a lawsuit about it. And if that happens, if the disclosure and the vote happens, then the transaction is presumed to be fair. If that doesn't happen, then the transaction is presumed to be unfair, and the burden is on the director or officer to prove that it was, in fact, fair to the corporation in order to not be held personally liable and to have the transaction invalidated. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, please subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.